anybody who might think that sabbaticals for law school faculty are paid vacations, I give you exhibit A and B. Professor Carmel, I'm not a corporate lawyer, but I must say that your incredible books, these volumes, are very hard. They're heavy to pick up, but they're very hard to put down. And they're a good read, and I have been reading them. It'll be my 5th or 6th year as a dean before I complete the read, but I love the book. And I want to tell you that Professor Carmel is so generous in acknowledging me and the Board of Trustees. And I'll tell you that it just hit me how fortunate I am personally, this is a personal note, Roberta, if you forgive me, to just be part of an institution like this. And I feel in this case like one of those ball players that gets traded to the championship team 3 weeks before the World Series and then just gets a ring for the World Series by just sitting on the bench and cheering, and that's what I've done in this instance. It's just a remarkable accomplishment. We're going to have I think, a really neat conversation tonight. And I want to let most of the time be available for you to hear from Professor Carmel about her work and this book, which is a real tour de force reprise of her work with new material and analysis. And it's amazing how many of the early pieces stand up and are so forward-looking that they're very, very applicable. She is a jewel in the crown of this world-class faculty. And when I say that, it's no toss-off line. We would be here all night if I started to mention the many accomplishments that she has had, and we know about her work early on as a businesswoman and as an enforcer, a prosecutor, as a regulator, writer, scholar, all of her accomplishments, just so remarkable, and I hope we'll get into them in detail. At this law school, she's been teaching since 1985, and the array of courses are breathtaking that she's taught over the past 30 years: corporations, securities regulations, European Union law, regulation of financial institutions and markets, investment market regulation, international securities and regulatory law, seminar on regulatory law. And, I was just speaking with one of our faculty members talking about how hard it is for us to be hiring in the corporate law and the regulatory area, because all we think about is we need to replicate Roberta Carmel, which of course is impossible. The mold was broken, and that can't happen. She's been such a key influence here for so long, and we hope she will continue for a great deal of time as the Centennial Professor of Law and also the co-director of the Dennis J. Block Center for Study of International Business Law. Of all the many things that Roberta has accomplished, one that is astonishing, and astonishing in how prolific she is in her leadership and development of a very, very large family. In fact, I think that there are probably more family members than faculty members here tonight. Now, we were expecting, I don't know if they're all here, but David Harrison, I know David's here, looking as dapper as ever, with a remarkable non-compass mentis tie. I think I can read that from here. Very nice. Philip Carmel, partner at Bryan Cave. Philip's here. And let's see, who has Barbara Landers, who's Phil's wife and is the director of the Graduate Affairs of New York Law School. There you are. Thank you. I'm glad that your law school allowed you to come over here across the bridge. Miriam Carmel, your daughter, a high school English teacher at the master's school. Dan Emery, who I just met. Dan, I know you're someplace. There you are. And a real entrepreneur, I'm told, by your very proud mother-in-law. And Miriam's husband is the husband, sorry. Dan is Miriam's husband. So he's the CEO of course he is. You're not the CEO. He's the CEO of New York City Guitar School and the author of, so I'm just giving you more material for the roast tomorrow night, you know, so. Rachel Harrison, who's not here yet. She's an artist. What do you, you know, this marches to her own beat. Eric Banks, Rachel's partner. I guess he's not here either. No, he is? Okay, they'll be here. And then Amy Siegel, who's the cousin and is the COO of Morgan Rio Capital Management. Son Jonathan Carmel, a lawyer for New York State Health Department and a BLS alum, and his wife Samantha are traveling and not able to be here. Solomon Carmel, a financial advisor, and his wife Martine, who is a manager at Microsoft, are out of town as well and unable to attend. And then also unable to attend are Roberta's stepson, Andy Harrison, who's a business consultant, and his wife Sharon, professor of economics at Barnard. And not one of her 10 grandchildren are here. I mean, I really think that you need to have 10 grandchildren. We're only up to 3, whereas you're here later on. We're working on it. We've got a 4th on the way, I just learned, so I'm going to ask you about that. Okay, without any further hesitation, I'd like to invite Professor Carmel to say a few words, and then she and I will have a conversation.
Thank you, Nick, for that very nice introduction and for mentioning all of my family members who are here, and I thank them for coming. And I also thank my former students, my current students, a lot of old friends and colleagues, and I really thank the faculty who are here because I know you have been listening to presentations every other day for the past few weeks, so anybody who wants to come and hear yet another presentation is very much appreciated. Let me say a few words to set the stage for this conversation. During the past academic year, as you just heard, I was on sabbatical, and my sabbatical project was this book. I pulled together for republication my descents as an SEC commissioner in the 1970s, my many columns for the New York Law Journal since 1982. It turns out to be 190 of them. And excerpts from law review columns, articles on related topics. So the result is this book. I was appalled that it turned out to be 2 volumes. I never saw the page proofs until this last Labor Day. If I'd had another year, it would have been shorter, 1 volume for sure. Reviewing my writings over so many years was a daunting experience. I was surprised that so much of what I thought and the views I expressed remained relevant. On one level, the book is a history of securities regulation over the past 50 years. On another level, it is a collection of criticisms of that regulation, criticisms that were often ignored. Nobody likes a Cassandra, which I was from time to time. The SEC is a larger organization with a greatly expanded mandate than was the case when I joined the staff in 1962 or when I was a commissioner in the late 1970s. Sadly, I think it is also less respected and less effective, and it is definitely less independent. During the second Bush administration, Treasury Secretary Paulson recommended that the SEC essentially be abolished, except for the Division of Corporation Finance and some regulation of the trading markets, not too much. After the 2008 meltdown, when Dodd-Frank was wending its way through Congress, there was discussion of the SEC's possible extinction. Instead, like the other financial regulators which failed to prevent the collapse of the markets, the SEC was rewarded with more power and increased responsibilities. This proved a mixed blessing. The Dodd-Frank Act was a very complicated, highly regulatory and prescriptive statute which imposed arbitrary and unrealistic deadlines on rulemaking by the SEC and other financial regulators. It applied band-aids to hold together the status quo without a serious congressional inquiry into the causes of the meltdown or how to bring the ailing capital markets back to health. At this time, the SEC has completed rulemaking in only 57% of the assignments given to it by Dodd-Frank and has not even proposed 24% of the 398 rulemakings required by that statute. In the meantime, Congress passed the Jobs Act, which also was prescriptive, and imposed deregulatory rulemaking on the SEC with another set of unrealistic deadlines. Even when the SEC was able to pass legislatively required rulemaking, the D.C. Circuit Court struck down rules as arbitrary and capricious or for other reasons. Also threatening the SEC is the Financial Stability Oversight Council, usually called FSOC, created by Dodd-Frank, which is a committee of all the financial regulators headed by the Secretary of the Treasury. As is often said, a camel is a horse designed by a committee, and I don't expect anything better from this committee. The White House and Congress really have insufficient interest and expertise for real financial regulatory reform. Regulated financial institutions and big public companies are too rich and powerful, and they are able to lobby successfully against regulatory reform. Congress, the White House, and the regulatory agencies have been subject to more and more capture. The too big to fail banks are bigger than they were before 2008. The trading markets are more fragmented than they were at the time of the 2010 flash crash. And disclosure regulation by public and quasi-public companies has been beset by such contradictory mandates under congressional statutes that is it a wonder that the SEC can engage in any intelligent rulemaking. Sadly, everyone is to blame for the sorry mess of the capital markets and their regulation. Big public companies, big banks, and securities traders have insufficient regard for constituencies other than shareholders, and their primary concern is the compensation of their executives. Politicians are primarily concerned with their own reelection and raising the campaign funds required for running for office. Academics in the business schools and law schools embraced a free market ideology which justified financial deregulation. The financial regulators accepted the mantra that the markets would solve all the problems of the world and never imagined financial institutions were hopelessly blind to the risks they were assuming. As a result, the public's faith in both government and capitalism has been seriously eroded. So, I'm going to suggest 10 principles for securities regulatory reform. Why 10? Well, there's 10 chapters in my book, and it's a nice round number. Some of these recommendations require new legislation. Others can be affected by the SEC through rulemaking. First, there should be a serious consolidation of financial regulators. At the very least, the SEC and the CFTC, the Commodity Futures Trading Commission, should be combined. The Dodd-Frank compromise of creating the FSOC is no substitute for agency consolidation, and to some extent makes the balkanization of financial regulation even more problematic. It should be recognized that the SEC's essential goal is investor protection, and the purpose of this goal is to foster capital formation and fair and orderly trading markets. Other mandates, such as efficiency and competition, should be placed on the SEC only to the extent these goals are compatible with investor protection. Although financial stability is an extremely important component of capitalism, adequate capital formation requires risk. Therefore, financial stability should not be a paramount goal of securities regulation as opposed to banking regulation. No broker-dealer or investment bank should be too big to fail, and any such organization should be dismantled into components that are not so big. Second, the SEC's independence should be preserved and strengthened by providing the SEC with a self-funding mechanism. Unless and until the SEC is self-funded rather than subject to congressional appropriations, it is but a pawn in political gamesmanship in Washington, and it cannot operate effectively. Third, the SEC should downplay regulation by prosecution as a strategy for enhancing its reputation. This is an old theme of mine. I even wrote a book called Regulation by Prosecution many years ago. In my opinion, the SEC should devote fewer resources to prosecutions after the fact, and instead should devote more resources to surveillance of the markets, regulation of securities firms, and rulemaking. In this connection, some of the roadblocks that have been put in the way of rulemaking should be removed. Fourth, setting up the independent director as a centerpiece of corporate governance reform should be recognized as a failed experiment. Much more emphasis should be placed on the need for director expertise. Many of the big failures and scandals of the last couple of decades, and I think particularly WorldCom, Citicorp, had boards of perfect independent directors who hadn't a clue as to what was going on inside those companies. Fifth, all companies which raise money from the public should be required to comply with SEC disclosure requirements and should provide their shareholders with certified financial statements. The provisions of the Jobs Act, to the contrary, excusing new public companies from reporting and disclosure obligations should be repealed. This regime is a dangerous throwback to the regulatory framework before amendments to the securities laws in 1964, and those amendments were prompted by serious abuses in the markets. At the same time, disclosure requirements for public companies should be rationalized and made much less complicated. The securities laws should not be used to foster social and political objectives that had little or nothing to do with investor protection. One of the serious problems standing in the way of reform of the securities offering process and disclosure simplification is the questionable state of civil liability for fraud in offerings or disclosure by public companies. The civil liability of the federal securities laws have been essentially gutted by the courts, particularly the Supreme Court. New and much more reasonable and consistent liability provisions need to be designed and provided for by statute. Sixth, a new regime of regulation of market structure is required. Just as regulation of public company disclosure for new public issuers has reverted to the legal regime of the 1950s, the trading markets have reverted to the over-the-counter dealer markets of the 1950s. Yet, there is a plethora of intervening regulation that firms must follow. In fact, some blame SEC's regulation NMS for the fragmentation of the trading markets. Others blame technology. The SEC needs to address the toxic combination of dark pools and high-frequency trading that have set the stage for a market crash waiting to happen. Furthermore, it should be recognized that those same institutional investors that the SEC sees as the champions of investors with regard to corporate governance are the causes of the problems in the public trading markets. Seventh, responsibility for compliance with the securities laws should be placed squarely on public companies and securities firms and their controlling and associated persons. While regulation of gatekeepers has its place, gatekeepers are only secondary actors. Yet, the oligopolies created and maintained by accountants and credit rating agencies are problematic. Further, Many of the problems with regard to faulty financial statements can be blamed on the formulation of accounting principles that permit financial statement obfuscation. The SEC, in my opinion, has exercised inadequate oversight over the development of accounting principles, and in particular, has allowed too many companies to push their liabilities off their balance sheets. Eighth, leverage and speculation are the causes of virtually all financial crashes. I'm going to say that again because it's something I've been saying for many, many years, and I believe it is the problems that we have encountered today. Leverage and speculation are the causes of virtually all financial crashes. The Securities Exchange Act of 1934 recognized this by creating a regulatory system for curtailing securities credit and manipulation. These insights were ignored in the last quarter of the 20th century and the first years of the 21st century. Leverage restrictions were debased by the development of derivatives. Other lessons painfully learned after the 1929 market crash were forgotten when financial services holding companies were allowed to engage in commercial and investment banking, securitization, and trading for the house with the funds of depositors. Even after the 2008 meltdown and the government bailout of Wall Street, serious trading scandals have been exposed. The London whale, the manipulation of LIBOR rates, and questions about foreign exchange trading. Ninth, I have previously written that the too big to fail banks need to be broken up, pursuant to a mechanism like the Public Utility Holding Company Act, which broke up the utilities of the 1920s, or some other mechanism. Dodd-Frank, even assuming the Volcker Rule is effectively enforced, which I kind of doubt, will not accomplish this task. The subsidies these banks enjoy due to the government's implicit guarantee of their liabilities is unfair to smaller banks and to the public taxpayer. This is very expensive corporate welfare. Further, the former leading securities firms have been transformed into protected universal banks. 10th, a special study of the securities markets has been recommended by some as a necessary predicate for securities regulatory reform. I agree, but there also needs to be a better, less partisan, and more dispassionate analysis of the causes of the 2008 meltdown than has thus far been set forth in the Financial Crisis Inquiry Commission report. Sorry. Unhappily, it is difficult to imagine Congress funding these studies or paying any attention to their conclusions. At least an internal special study by the SEC, if the funds for this could be found, could be implemented to some degree by SEC rulemaking. So now none of you have to read this 2-volume book. This is a summary of what's in there. While I do not believe that the capital markets and their regulation are completely broken, I do believe they are in need of very serious repair. Like everyone who has worked in a field for a long time, perhaps I have too rosy a view of the markets and their regulation in the past. But I honestly think that regulators and politicians, as well as the public at large, ignored economic history by allowing and even encouraging the dismantling of legal requirements designed to curb leverage and speculation in the capital markets. While technology has changed the markets and made them more competitive, it has not eradicated greed and dishonesty. I taught a seminar about securities regulation in the spring of 2010 when Dodd-Frank was being designed. In the first class, I went around the room and asked each student, what do you think caused the 2008 meltdown? More than one student said, moral failure. Technology and the changes in the capital markets changes in the capital market technology has caused does not allow securities market participants to distance themselves from responsibility to either an industry or the public. Because underwriters and traders interface with machines instead of human beings. At one time, securities firms had fewer conflicts of interest because the securities industry was based on a segmented model run by partnerships. Some were managing underwriters, others were wirehouse distributors, others were trading houses. The New York Stock Exchange, when it was a mutual organization, for all its faults, was a community. The SEC was smaller and had a more limited mandate. The challenge of injecting a new sense of community into the firms in the capital markets is daunting. It may never come about. And a serious problem of securities regulation is the adversarial relationship between the SEC and Wall Street. At one time, a securities industry leader might have gone to the SEC or the New York Stock Exchange and said, Madoff may be a crook running a Ponzi scheme, or the amount of credit derivatives in the markets are dangerous. But these conversations did not occur. At one time, it was illegal to evade certain Federal Reserve Board rules, such as the margin regulations. I remember working on matters like that. But then evasion of rules was perceived as a way to reform an outmoded regulatory system like Glass-Steagall, and it was encouraged by the Federal Reserve Board. Perhaps I'm indulging in nostalgia when I claim that Wall Street used to be more of a community. But unless banks and investment banks and traders become more imbued with a sense of obligation to the system and return to a culture of obedience to legal requirements, all the regulatory reform in the world will not put a fragile Humpty Dumpty capital market back together again. And I see some of you frowning like you used to do when I taught classes, so I hope this wasn't too deep, but I thought this is a serious book, so I should give a bit of a serious talk. And now Nick is going to try and make this a little more lively.
You still have to read the book, because that was just a brisk walk through the afterword, chapter 11, of forward-looking recommendations for how to improve financial regulations. There's still about, 1,200 pages of rather deep and rich material, and it is a good read, even for somebody that is not a layperson. I know Marla is, I can hardly get a chance to read it at home because she's pouring through it. But what I wanted to start with is some questions, Roberta. I wanted to start maybe with some biographical material. And one thing I'd start by reading, though, is to say that I have a message here, an email from a former student who's a very accomplished former student. And she writes, Professor Carmel is a dedicated mother and grandmother, a terrific wife, and also a trailblazer in her own right. She mentored me professionally, but also on the personal level of balancing between being a mom and having a career. So, I mean, that's just a wonderful tribute, and I'm sure there are so many that can say that. What I'd like to ask you, very mindful of having my 3 new young grandsons, soon to be joined, we've just learned, by a granddaughter. So this is on my mind. Now, what would I tell Professor Carmel, what would I tell my granddaughter about how you became you? You know, you had a keen interest in business and financial business from a very early age. Your father had a big influence on you, but you went to top schools and you worked hard, but you were consistently autodidactic. You barely mention actually college and law school in the book. Along the way, you rubbed shoulders with incredible people. You sort of toss off, well, you know, I was present when Sandy Weill made his first $1 million before he started making $1 billion. And, you know, Arthur Levitt was sort of around at the time. And you've met in your life a remarkable cast of characters who must have had an impact on you, but you've always gone your own way. So what I'd like to ask you is, we want to hear a little bit more about how you became you.
Well, that's a big question. I think the answer is, at a very early age, I started thinking for myself. I always tell a little story about that. When I was young, I was very nearsighted. But nobody noticed this until I was in third grade. And then the teacher said to my mother, I think Roberta needs glasses. So I got glasses. And I thought, this is wonderful. I can see what's going on in the world. And I said to my mother, I didn't know grass was those individual little sticks. I thought it was just a green carpet. So, and then a friend of my mother's came over and said, oh, it's too bad. Such a pretty little girl has to wear glasses. And I thought grown-ups knew everything and were smart. This woman is stupid. And at that moment, I realized I was going to have to start thinking for myself and not accepting what the grown-ups of the world or teachers or other important people were telling me.
You were 8 years old.
Yes.
Okay, and then what happened?
I think actually, although it's not mentioned in the book, I was quite influenced by college because I went to an Eastern school. I went to Radcliffe, and I majored in American history and literature, and it was really intellectual history, and it actually gave me a framework for looking at the world politically in terms of politics. And law school was important. That's how I became a lawyer. I loved law school, unlike many of you.
All right, well, I want to return to your independence a little bit, but just one last aspect of this, and that is that I think it's remarkable, not just at the time and place, that you had such an intense interest as a young woman starting work out of the home in business, and not just in selling, retail products or sort of even traditional areas of business, but in finance. I mean, how did that happen?
Well, I think my father probably was very influential in that regard. When I graduated from college, I went around in Boston trying to get a job, and even though I had this fancy degree, there weren't that many jobs available, and partly because my father was so interested in the stock market, I got a job in a small over-the-counter brokerage firm, really in the back office doing ministerial things. I thought, this is great. It's very exciting. I like that. And then when I was in law school, it was so difficult to get a job at a big firm. It was almost impossible for women. And I was able to get a job at the SEC in New York. Actually, first, I was offered a job at the NLRB in the general counsel's office, and I really wanted that job. But that was in Washington, and my late husband was still working on his doctor's degree here. We had to stay in New York. So I took the SEC job, and after 6.5 years in the New York office, I was a securities lawyer.
Was the government generally a friendlier place to start for women?
Yes, although even the government was not as friendly as it later became, because this was before the 1964 Civil Rights Act. In fact, I remember after investigating a particular case that I worked on directly with the Associate Regional Administrator at the time, he said to me, you were hired over my objection. Didn't have to say because you were a woman. He said, but you've turned out okay.
Okay, well, so I now know why you waved me off and didn't want me to ask you about the Jumpstart Our Business Startups Act or the demystify the alphabet soup of the regulatory agencies that impact finance, because you're going to talk about it. So let me continue on another topic. One is that you toss off some things that even though they're in English, for me, I read them, I have no idea what you're talking about.
I'm sorry.
An example, a specific example is right at the beginning of the book, you say that your father, quote, blended a belief in issuer fundamentals with Chartist theory. I'm not going to ask you to explain that. I don't even want to know what that is. I have no idea. But then what is more, by the way, my father would kick me if he heard me say that about him. So, but what does strike me while I'm swimming in those deep waters is that you say other things which I completely understand, but I really remarkable. I'm going to ask you about one of those. You say that after all this time, and you've now just done this work, so you've revisited in a very intimate way your life's work in writing. Do not know whether your views have changed or remain the same. And that's pretty clear English, and I understand it, but I think that's remarkable. Is it true? I mean, what do you
Well,
think?
that's what I wrote when I started writing the book. I did the whole book, and I would say, well, the markets have changed, regulation has changed. I don't think my fundamental views have changed, but when I read some of these law journal columns, I thought, oh, this column is a little dated. Some of my fundamental views, such as the one I remarked before, leverage and speculation are the evils of the markets. Yes, that view hasn't changed. I wrote a whole book called Regulation by Prosecution, and when I was at the SEC, I objected strongly to the prosecutors pushing the envelope and creating new violations through enforcement cases. As I've gotten older, I realize how difficult it is for the SEC to engage in rulemaking. So maybe I'm a little more understanding of that dynamic, even though I still don't really approve of it.
Well, I'm going to ease into asking you a substantive question.
Okay.
So you not only broke into the club, you not only completely destroyed the glass ceiling. When you got into the club, you just didn't set into the standard easy chair. You went your own way, which is quite a different thing. And a big example of that are your dissents as commissioner. And you were writing dissents at a time when there was no mechanism for writing dissents. It was unheard of. Everybody sort of went along. So they had to create, I guess at your initiative, a way for dissents to be filed. Now, one of the things that you consistently dissented on was your view that in many, many areas, the commission lacked statutory authority to do what it was doing. Now, in most cases that I'm aware of, subsequently, many years later, Congress granted the commission the power that you said it lacked, which kind of proves that you were right in most cases, even though you were dissenting. Tends to, although people that interpret legislative history know that you're not supposed to make that argument. But in any event, so my question is, do you think that Congress should not have granted that? In other words, that the commission should not have that authority, or that it was a good thing that Congress blessed what was actually, de facto happening at the commission?
Well, I much prefer to see the commission bringing cases according to statutory authority that it has. So in that sense, I think it was a good thing. In a couple of areas, I'm not so approving of the policy of all of these enforcement tools. I think that there's too much. There's too much of that. But that's more of a policy view. I think in terms of if the agency is going to go down a certain road, I think it should have clear statutory authority for doing so.
So maybe as part of agency consolidation, they could pare back or rationalize some of the jurisdiction?
They could, but it's never going to happen. Never going to happen.
Okay, next question. So your 40-plus speeches during the time you were commissioner and your countless columns and other writings were widely read and very influential. What, in your view, was the most, if you had to pick one, or a series of one on one topic that had the biggest impact, or the most important, which one would you think it was?
Well, I guess I wrote a law review article called "Is FINRA a Government Agency?" That it has had more downloads than anything else I ever wrote. So if you think that's important, and I'm not sure it is, I would say that's the most influential. And people do I think that's an important article. Another article that was very widely followed was one I wrote with Jim Fanto, who I'm glad to see is here tonight, on why foreign issuers come and list in the U.S. We wrote that as kind of a lark, and then it was turned into an empirical study by some very good students in Stanford, and it really got a lot of attention. In terms of articles themselves, I think one of the articles which I wrote in 1990, which was called A Decade of Greed, which was about the 1980s, also got a lot of attention, and I think what I said in there was right. Unfortunately, we then had 3 decades of the same old thing after that.
Somebody wrote a movie about it, right? Wall Street.
I started out quoting the Gordon Gekko speech in that article.
It wasn't an accident. I didn't make it up myself.
No.
So, I'm not going to ask you about the primary cause of the collapse in 2007. You sort of answered it because you explained what the primary. But in your view, what are the primary causes of the SEC's loss of reputation from the golden years? And can they put the genie back in the bottle? Can it restore its reputation, or is it gone for good?
I don't know. I mean, I think part of the problem is the poisonous partisanship in Washington that has adversely affected every government agency. So it's not just the SEC, it's many other parts of the government also. In terms of the SEC, I think they've been too ambitious. Another article I wrote, and I can't quite remember when, said that one reason the SEC is so respected is that it's a very small agency with a limited mandate and a limited budget. Now it's much, much bigger, and it has such a greatly expanded mandate that I don't think it can handle all of the jobs that it has been given to do. So I think rationalizing the securities laws is something that is important. More focus, yes.
Focus on capital formation and investment protection.
Yes, yes.
And no enforcement by prosecutors.
Not none, but much less.
All right, well, talking about enforcement, I think one of the big blows, and I'm not by any means even close to being an expert in this area, but as a quasi-lay person, how did the SEC miss Madoff?
I don't know. I think it was partly because Madoff was, at the time, an important leader in the securities industry. And it's one of the problems with the agency. There's always been a fear of going after people who were too big, too important. This happened to me when I was on the staff. I brought a case
Too big to flail.
Against some member firms, and I was told, oh, be careful, those are member firms. I said, members of what? I was so naive. So I think that was one problem. I don't know. I mean, I think it was a period of such rampant deregulation that a lot of things got missed, and that happened to be the biggest scandal that there was. Yes, I think the Madoff affair greatly tarnished the SEC's reputation. I think another problem has been all the cases that the SEC lost in the courts.
And why did they lose them? They went from one extreme to the other. They went to the extreme where, as you describe in your book, the cards are really stacked, right? And they're focused and they're prepared well, but the cards are stacked. So you're winning your cases, so your reputation is high. Then what happens? What causes the loss of?
I think a combination of overreach and a failure to really appreciate political changes. I mean, when Landis was at the SEC a long, long time ago, his philosophy was the SEC should never bring a case unless it was airtight and they could win. This is no longer the philosophy of the SEC or other prosecutors. I mean, they think it's a good idea to bring as many cases as we can, and if we lose some, you win some, you lose some. That's litigation. But I have never gone along with that theory.
What do you feel about a trend that seems to be taking off involving litigants and regulators, not just going after the defendants, the alleged wrongdoers, but their counsel?
Oh, I've never liked that. But then maybe I'm biased because I'm an attorney. But I think...
It's a huge trend.
Yes. I think this, and I mentioned that in my little talk, I think this going after gatekeepers has always been a kind of mistake. The gatekeepers, I mean, these people are not gatekeepers. Attorneys particularly. I mean, I think accountants, the credit rating agencies, yes, they were supposed to be gatekeepers and they failed. I don't think attorneys were ever supposed to be gatekeepers.
Well, it's a very corrosive development, and since our justice system, our legal system is built on counsel being the officers of the court, and that's the basic theory. When they are attacked and their clients lose their ability to have the counsel of choice because they're somehow destroyed, it screws up the whole system, to use the Latin phrase.
Well, I think in some of these cases, you had very bad facts. John, who's in the audience and my counsel when I was at the SEC, remembers the case that was probably my most famous dissent at the time, Keating, Muthing, and Clamp, which was a Rule 2E case against a law firm. This was the former law firm of Keating, who was a very bad guy. He was one of the SNL kingpins.
That's the case that prompted me to ask this question.
But still, bad cases make bad law. I mean, and this was a case against a law firm in which he was no longer even a partner, and he'd already been enjoined by the government. So I say it was my most famous dissent, and it used to be in the securities law case books, and I don't know if any of my former students here were there when it was in the case book, and I was always kind of embarrassed about it because I'd say, well, this Commissioner Carmel wrote this opinion, but it was a dissent. This isn't the law. You have to be careful about it.
But your dissents have a way of becoming the law. So, all right, I'm going to ask one final question, and then we'll take some questions from the audience. I'm sure that many people want to have some things on their mind that they want to raise. You have worn so many professional hats. I'm not going to ask you about your personal hats as a spouse and a homemaker and a mother and a grandmother.
You should ask my children about that.
I will. But what I'm going to ask you is, things that you've done, scholar, a journalist, prosecutor, commissioner of a government agency, private practice, very successful, and a business person. What was your favorite job? If you had to choose and you had to spend your entire career just doing one, and you were forced to do that, which one would you choose and why?
Oh, I think there's no question it's being an SEC commissioner. I mean, that's like the dream job for any securities lawyer. Unfortunately, that's not a lifetime appointment, or maybe just as well for the SEC. And then a close second was being on the board of the New York Stock Exchange in the days when the New York Stock Exchange was still an important U.S. institution. It really isn't today the same institution it was then.
What a career. Well, thank you very much. It's just
They're speechless.
Is it got law professors and law students in Canton. Yes, sir. There you go. Well, there you go. Dan Emery.
I have a question. What were some of your personal habits and perspectives that led you to have so much success over such a long period of time?
Again, you have to ask your wife, but I would say kind of two related things. One was I was always extremely organized, so I think organization, management of your own life is something that's very important for success. I think the other is something that maybe was good, maybe it wasn't, was a kind of compartmentalization. Is when I was at work, I really didn't think much about what was going on at home. When I was home, I didn't think that much about what was going on at work. I mean, kind of two different lives almost running in parallel.
Yes, sir. Oh, Jim. Professor Manta.
Well, I don't have a comment. I just have to say that you're just being too humble. Like, to answer that question.
You're not talking to me, right?
No. Roberta. I mean, surely everybody who knows Roberta knows, like, one of your great attributes, and I'm sure why she's been so successful, is that even when people, like, argue with her and dissent, with her, she's always very level-headed and kind of can deal with a very, detailed argument, that with someone arguing and confrontational with you in a very calm way. I'm sure that, right? That had to do with a lot of your success. Do you agree?
Well,
Are you gonna-
people used to say to me, more in the business world, maybe than at home, is you know how to listen. And I think I always was very interested in what other people had to say, what their arguments were. Certainly when I was in practice, I was very interested in what the objectives of my clients were, even though sometimes those objectives were not quite on the up and up, and I had to talk them out of those objectives. But yes, I mean, I think I have always been very interested in what others thought about a topic, and I always took securities law and other legal endeavors very seriously. I would say I was also willing to work as hard as anybody who was working for me, and I think that is an important leadership quality. Oh, Anita.
Oh, sure.
Practicing Law Institute.
Since you've been a role model for many of us in this room and practiced at a time that technology didn't provide the avenues to be in touch 24/7 as they are today, you were able to achieve so much. What are your thoughts about what I would call work-life balance, if that's even possible, given the technology that lawyers have at their hands today? Because your comments about when I was home, I thought about home. When I was work, I thought about work. I think today is a standard we should all strive for, but I'm curious what your comments are on that.
I think it's much more difficult today. I often say this in advising students about their careers. I mean, I did not work 24/7. I was not in contact with my clients 24/7. And in fact, I used to feel, and maybe this made me less than the kind of lawyer that people are expected to be today, is yes, this client's having a crisis, but it's their crisis. It's not my crisis. And it's only about money. It's not my money. And the only time I have to say that I ever felt a crisis was a real crisis was in situations where the government, whether it was the SEC or the U.S. Attorney, was kind of after my client, and I thought, oh, this really is a crisis. They could end up in a lot of trouble. But deals, I had a different attitude that would probably not be appreciated in most law firms today.
Right.
Amy.
Well, let me just comment on that. I mean, what I'm really hearing, which is very interesting, is a sense of judgment and ability to prioritize, right? And there are emergencies, and then there are real emergencies. And so, but you know, it's nice to say after you've already been the first woman commissioner, and chairman of the Practicing Law Institute. You know, yeah.
When you talk about leverage and speculation as being the two main evils, I can define leverage, but how are you defining speculation? Because some would argue that risk-taking or some subset of speculation is what America is made of.
Well, I think that's a very good point, actually. And coming from you, you're in an organization that engages in that kind of risk-taking. I think maybe I should have used the word manipulation, but certain kinds of speculation. In the 1920s, it was the pools that were outlawed in the Securities Exchange Act of 1934. And since then, I think we have some activities in the market that are similar to those old pools that are really very manipulative. So no, I think there should be risk-taking in the capital markets. Yes?
You mentioned the need for securities reform, but can you comment on your thoughts of the current securities reform, namely the Dodd-Frank Act? What about this Mammoth Act, often called the Keep Lawyers Employed Act, myself being a beneficiary of that, what do you feel that it got right in terms of Wall Street reform and securities law reform, and what concerns of yours do you feel that remain unaddressed by this?
Well, to give a good answer to that, Diana, you'd have to take another class with me. But in summary, I would say it got right. I would say the VOCA rule, if it wasn't, 300 pages long and unlikely to ever be vigorously enforced, but the idea that trading should be divorced from commercial banking, I think that was a good idea. And I think some of the other reforms of the regulatory system, what it got wrong is that it didn't consolidate the regulators. Instead, it created two new ones. The worse balkanization than we had before, and that it's too complicated. I think that regulation today is too, I always say, the Glass-Steagall Act, which I'm not saying we need to go back to that exactly, but the Glass-Steagall Act, which regulated the capital markets for many, many years, fit on one page. I mean, it's true, there were many Federal Reserve Board and other interpretations of various parts of it, but it was a basic, simple regulation. Dodd-Frank is too full of too many complicated compromises.
2,000 pages. And not one member of Congress left. Not one. So I'm going to ask the last question, and then we'll have a chance among ourselves, and we'll talk with Professor Carmel over some wine and cheese. So the last question is, in this brave new world that we live in, where the G7 has moved to the G20, and people realize that they are greatly constrained because of the porousness of borders when you're talking about capital movement and finances. But they all have to work roughly in some kind of parallel at the same time, otherwise investments and money flows to the most favored regulatory climate. I mean, what is the future of a national regulator? I mean, what is it that they actually can do?
Well, this is something I've spent a lot of time on in my scholarship, and there's a long, long chapter in the book on international securities regulation. I think a national regulator is limited. But I think in the world we live in today, it's very, very difficult for regulators from different countries to really agree on what the regulatory system should be, because the regulators and the market players are all in competition with each other. So the best we can get is a certain amount of harmonization or agreement as the contours of regulation. And some of that has happened. Some of that has happened with the banking regulators anyway, and even the securities regulators. But it's at a level of great generality. When you get to the details, it's probably not so possible because the different capital markets and corporate finance systems in different countries are different. I think you have much more agreement, actually, and cooperation between the U.S. and Europe than you have between the U.S. and anywhere else in the world.
You mean Canada?
Oh, yes, Canada is fine.
It's sort of like Europe, right?
No, it's sort of like the United States. I mean, the Canadians have copied our regulation, really.
Yeah, well, they had larger capital requirements, though, right? They didn't have the same meltdown.
They had a different system for bank regulation. They don't really have a different system
Oh, you mean there's a
for
difference
securities
between securities
regulation.
and banking?
Yeah, some.
Okay, on that note, before I completely reveal how naked I am intellectually here, I thank this terrific audience for coming, for asking questions. I'm extremely grateful for, as always, our event staff, the guys in the back. They're constantly working all hours, Linda Harvey, her whole team, and especially Liz Alper, who put a wonderful program together. And most of all, Professor Carmel, we thank you for the privilege of working with you and following your work with such great admiration. Thank you very, very much.
Thank you. And you. To say there's one thing I didn't get to say because nobody quite asked me the right question, and that is to have the life I had, one requirement is to have healthy, cooperative children.